Hi, I'm John Baxter from Baxter IP, and I'm talking about technology licensing. In this week's blog, we're going to be talking about joint developments and other legal terms within a license agreement. Under certain circumstances, joint developments can also be planned to be conducted by the licensor and licensee during the term of the license agreement. These agreements are sometimes called development license agreements or DLAs. Their management, funding and execution logistics need to be agreed up front to avoid huge problems later. The ownership of any resulting IP needs to be worked out up front for this situation. Is the IP to be jointly owned, for example, or will the inventing party be allowed to own the IP and license it into the agreement, even if the development as such is joint? Lastly, now for some general terms. These terms are common to many other types of contracts. The legal warranties to be provided by the licensor, if any, need to be agreed on. Note the validity of the licensor's patent should never be warranted. The licensor will normally insist on the right to audit the licensee, for example, to inspect the financial accounts and/or the sales records of the licensee to ensure correct royalties are being paid. The audit provisions always need to cover the awkward situation in which the audit reveals either underpayment or overpayment of the royalty. The relationship management of the license agreement by the parties need to be agreed. For example, the frequency of regular meetings, reporting requirements, distribution of reports, etc. Is the licensee required to report to the licensor any changes in its competitive environment? Does the licensee have to give the licensor forward estimates of its sales volume or breakdown? These are important questions which should always be established up front. A specified written communication channel between the licensee and licensor should always be established. Normally, to avoid any confusion or loss of vital information, a particular person or person in a particular position is nominated at the licensee and licensor for receipt of all written communication regarding the license agreement and the obligations contained therein. As in any common sense contract, a multi-tiered dispute resolution procedure should also be spelled out up front in order to cover the situation where problems arise between the licensor and licensee during the term of the license. The last thing we want to end up with is litigation in the courts, and as we all know, it is only the lawyers who win in this situation. And again, as per any other contract, the applicable law needs to be agreed under which the license will be contractually executed, and under which any litigation will eventually occur between the parties. That is, of course, if dispute resolution cannot settle an issue up front. Always try to agree in the first instance that the applicable law is the law governing your Australian state. Anyway, I hope you found this very brief treatise on IP license agreements helpful, and remember to always seek professional assistance when trying to draft such contracts. There are many pitfalls for the unwary. I'd also suggest that you start by talking to a patent attorney firm. Intellectual property law is a very specialised area, and in Australia, in my opinion at least, there is even more limited practical experience in the area of IP commercialisation and IP licensing. Remember that seeking the right advice up front will always optimise the robustness of your license agreements and hence the eventual commercialisation of your IP. Thank you.